Hi guys. It's Tuesday, right? Happy Tuesday. Hope everybody's doing well. We are going to be doing another YSL reunion. So what we're going to be watching, it, it's not a replay from the trial. We're actually going further back to 2022, December 15th. There was an issue with this hearing where somebody decided to Zoom bomb with their junk out, and the full streams of this trial are all piecemeal, chopped apart. So I compiled everything that I could find related to a crucial motion filed by Jeffery Williams, young thug, and argued at this hearing by Brian Steele. This is in relation to suppressing evidence obtained from a cell phone that was seized during an unlawful search of Jeffery Williams' residence. Part of the reason why we're watching this now, twofold. One, love makes some rambling on and on arguments during this pretrial hearing. So we've been doing Love-a-Palooza as our theme for the first stuff that we're rewatching. Secondly, we recently rewatched the testimony of Tick and heard a lot about his plea deal, which came about December 27th, 28th, 29th of 2022. We've also been talking a lot about Mounk Tounk's plea, and to me, the timing is just raising new alarms. So I wanted to revisit this. So we're going to do that together. I have to give a big shout out, not just to Fox 5 and 11 Alive, who had like 30-minute clips of this full day, but the lead attorney actually streamed this entire hearing. It's still up on his channel. I don't think he knows why it was pulled down. He has AV to the seventh power co-hosting with him. I've linked to that in the description of this video if you want to watch with their contemporaneous commentary. But I've cut down all of the audio glitches and the blurred screens. So what was about 6 hours, we've gotten down to about an hour and change. I actually recorded this at 1.25, so we're going to slow it down. It'll probably take us about an hour and a half. So with that being said, please understand that there will be jumps in the video. I tried to put a window on the screen, and I'll say it out loud when we're missing like 10 minutes, 30 minutes. That way you know if we might be missing context or if we're just skipping a break. But just know that this is not a perfect raw stream. It's just everything that I could find and put together. So hey to Shirley, hey to my BFF Biff. Gerald, yep, here we go again. We're going all the way back. Thanks, Biff, for the reminder to hit the like button. Phoenix, good to have you live. FFS, boop right back. That guy, Nick, this Aussie news is real sad. My mom, I gotta call her. As soon as we're done with this, I've got to call my mom and make sure she's good about this news. Just sad. It's always sad to hear that somebody has passed away. It makes you think about time being short. Gotta appreciate the moments that we're in. Amanda, good to see you. Jess, good to have you here live. Let's see. And then STS, I'm seeing STS love, and lo and behold, here's STS going, dropping gifted subs. So big thank you, supporting the channel. This wonderfully rough editing work is sponsored by STS. I hope I do you guys proud. That was a horrible thing to sift through and try to patch out all of the bad court audio and when they cut the Zoom feeds. So we'll say the STS sponsored that work. So big thank you there. Trakisha, good to see you in the building. Shannon, Andrew, Aaron. If you say motion to suppress 3 times, Aaron, aka Adventure Aaron, will arrive. Good to have you here. I can't wait to see you. I'm sure you've seen this before, but you know, I already know you'll have comments. So, Julie, good to see you. Hey, Zariah. Let's see. Oh, what? Wow, time flies. See, time is precious. Amazing news here. We spoke about this somewhat recently, I think. But let's see. I know this was a Missouri case, and that's where Aaron hails from, or at least he lived there. I don't know if you're initially from there. But a year. And I hope that nobody's still messing with him, are they? Ah, holy moly. Yeah, time flies. I feel like I was just thinking about that case like a month ago. Not even. Factual lie, good to have you. Sorry, this is a late one for you. Andrew, good to see you. Sammy's in the building. Hey, Tracy. And Ninerette. So let's get going, you guys. I don't promise that the captions are good, but there are captions. So sorry in advance. And let me know on volume.
Thank you. All right. All right. D1 was the accusation that was filed in this case. D2 was the motion to suppress any and all evidence located from the defendant's home. D3 was a supplemental motion to suppress any and all evidence located from the defendant's home. D4 was the order granting supplemental motion to suppress any and all evidence. And it reads as follows. After hearing testimony, a stipulation of testimony and argument from the parties on Monday, April the 3rd, 2017, this court hereby grants the defendant's supplemental motion to suppress any and all evidence located from the defendant's home. Based on this ruling, the evidence located in defendant Williams' home is subject to the above referenced accusation number 16 SC1, and there's 6 fours. Specifically, that just over an ounce of marijuana, it is hereby suppressed and cannot be used in evidence by the prosecution in the trial of Jeffery Williams, signed by Henry Newkirk on the 10th of April, 2017. There was a motion for reconsideration that was filed or accepted by the clerk's office on the 20th of April of 2017. There was an order, that was D5. D6 is there was an order by Judge Newkirk entered on the 24th of April, 2017. The order, it reads as follows. The court having read and considered the state's motion for reconsideration, the same is hereby denied. D7 is a motion for null pros on the same case where Mr. Steele filed a request to have the accusation null pros. D8 is the dismissal for want of prosecution. When the case was called for trial, the state was unable to proceed, and Judge Newkirk has the following reason: the motion to suppress was granted, and he granted the motion to suppress, and that was the 3rd of April, 2017. There is a exhibit from our last hearing on the 17th, D9, which is a letter that was written by Mr. Steele to Mr. Charlie Bailey, Esquire, May 17th of 2018. They read the State of Georgia versus Jeffery Williams, accusation 16 SC1 for 44444. Dear Mr. Bailey, I hope it all is well with you and your family. I'm writing you to pursuant to my representation of Mr. Jeffery Williams in the above referenced case. As known, the Honorable Court suppressed all the evidence in the case was null pros and prosecution has ceased. Mr. Williams has been attempting to obtain his property that is lawfully his concerning the above referenced case. The City of Atlanta is not releasing the same as they still have the same marked as evidence according to Mr. Williams' father. Could you please assist in having the property released to the lawful possession of Mr. Williams or his designee? Please call upon receipt to discuss the above. I look forward to speaking with you soon. Signed, sincerely, Brian Steele. Copies to the 2 Williams, one being the defendant, one being the senior, his father. D10 is these warrant for search and seizure. And those were the 10 exhibits that were admitted for the court's consideration on the motion on the 17th of November. So the court's concern is that while you all, the state that is, think that Judge Newkirk did specifically excluded marijuana, he did, but the legal premise behind it would be fruit of the poisonous tree. Anything that was taken in that house at that point in time would be subject to being suppressed. And that's the first thing I'm going to let you all address. The second thing that would be of note is that under 17-5-30, this property was requested to be returned. And the statute's pretty clear, shall not be used in a future criminal prosecution. That is different than the return of property statute during trial 17-5-54. So yeah, that's why I preface this. I've had an opportunity to take a look at Judge Newkirk's transcript, which will also be included for purpose of record, is the next court exhibit from the 3rd of April of 2017. So with that, Ms. Love, what say you and your colleagues?
Yes, Your Honor. First of all, Your Honor, my understanding the court's review of the transcript, I want to point out that in looking on evidence that pertains to the possession of marijuana charge that Mr. Williams faced in that indictment, the court specifically, during the course of the proceedings, clarified during an exchange with the prosecutor, he is only seeking to suppress the marijuana.
I agree with you that, but the legal premise would still hold on anything that was taken in that home by a search warrant. You had an arrest warrant issue, and then you had a search warrant issue. So if Mr. Steele challenged the arrest to begin with, the warrant or copies of the arrest warrant and the warrant under Baez, which he versus the state, which is a 206 Georgia 552, which he cited at that point in time, that would make it so that anything else in the house that was taken would have been subject to being suppressed. Mr. Steele amended his motion. He asked for everything.
Oh, audio cut out.
And we got Lee letting us know the audio's cut out. So for anyone watching, for anyone listening and not watching, there was like 10 to 15-ish minutes of audio cut out here. I wasn't sure what speed Lee was playing it on. But yeah, so there's no, I don't have any footage I could find of what was said then.
Okay, so I do have the transcript from April the 3rd of 2017 with, and I've labeled it as the court's next exhibit in order. Court's 2 for purposes of this motion.
So, Your Honor, if I may go backwards for a second, if that's okay, I'd like to just first discuss and take care of State versus Alford. It's ALFORD, and it's 347 Georgia Appeal 208 that the Honorable Prosecutor has cited to this court. It's in Division 3 that the prosecution is relying upon, and it is wholly inapposite to what we're dealing with here, which is the transcript from April 3, 2017. Has nothing to do with what happened in Alford. In Alford, Mr. Alford is a passenger in a vehicle. The car gets stopped. Law enforcement officers see open containers and they smell marijuana as they approach the car. The officers then ask Mr. Alford, is that your backpack at your feet? And the answer is yes. And there's contraband, there's drugs inside the backpack. Mr. Alford is arrested and he's prosecuted for that. The Honorable Trial Court had a pretrial motion to suppress. And the state of Georgia was on notice that Mr. Alford, just like the Honorable Mr. Williams, challenged the actual arrest. And the state of Georgia did not bring in a certified copy of a county ordinance saying that a person can't have an open container in a car. Because of that, the trial court granted the motion to suppress. The state of Georgia appealed. What happened in the Court of Appeals was as follows. The Court of Appeals said, that's exactly right. Without introducing the certified copy of the county ordinance, there was no arrest for that purpose. But what the court then went on to hold is, however, when law enforcement officers lawfully walked up to the car, they smelled marijuana. And the odor of marijuana in the state of Georgia is a reason, probable cause, to search the car under the automobile exception. And because the automobile exception kicked in, it didn't matter that there was no certified copy of the county ordinance, and the Honorable Court of Appeals of Georgia found that the odor of marijuana was sufficient probable cause. The police then could search the car under the automobile exception. The backpack then, therefore, should be searched. The contraband inside the backpack should not. I don't mean to be rude. It is just not even close to what we have here.
Can I hijack for a second, Mr. Steele?
Of course.
We're going backwards. We should be going forwards. That I agree with you with at the status of your hearing in front of Judge Newkirk. The issues involving the search warrant, the arrest warrant, the search warrant, and these issues would have been. It's a snapshot in time. Since you filed another motion to suppress, the state now is willing to at least present forth evidence to show that the arrest warrant, the search warrant, and the seizure of these particular items, that there's a basis because we've gone forward and it's another case. So can you address that for me? Because I don't believe that I have to kind of look at it from my foxhole because this evidence is related to you filed a motion to suppress in this case. So I can't rely totally upon what Judge Newkirk has indicated. And also, this case was never appealed, so there's no really appellate ruling on this issue. So I would argue it's ripe to consider again.
I would respectfully disagree.
This is one of my favorite monologues from Steele.
I would argue it's ripe to consider again.
I would respectfully disagree. I wish I could do that in every case that I don't win, that I can come in and do a second bite at the apple. This is the exact
But it's a
issue.
different case.
No, it's, so then the state can just, I win a motion to
No,
suppress.
it's a different, okay, it's a different case. That was just a possession of marijuana case. This is a RICO case, and this is they're arguing at this point in time, since you filed another motion to suppress, that we look at probable cause and the other things from the vantage point of 2022.
Your Honor, I filed a motion to suppress based upon the law of the case. It's a final order. It was not appealed by the state of Georgia. It is a final order. It doesn't matter if it didn't go up to the appellate court. And it is the same issue that's already been litigated between the same parties, Mr. Williams and the state of Georgia. There's still the state of Georgia. It is res judicata and it is collateral estoppel. And all that is in my motion to suppress. Also, it is not accurate to say that Judge Newkirk did not consider fruit of poisonous tree. Judge Newkirk considered the following. My motions, which are in front of the court, the original motion and the supplemental motion, challenges everything that was taken from Mr. Williams' home.
Your motion to suppress is D2 and your supplemental motion is D3.
And it challenges everything that was done because the police unlawfully, as found by the Honorable Judge Newkirk, entered Mr. Williams' home. So what happens at our hearing, specifically at transcript page 18, this is on my cross-examination of the lead officer, line 3. The answer is, yes, sir, I do believe there was an arrest warrant. I interrupted. I didn't mean to interrupt, but I interrupted. I said, I didn't mean to cut you off. The answer continues. That is what the warrant was for. Yes, sir. Then my question is, and that warrant was from a long time before. If you know, and if you don't know, we can get the information through someone else. Answer, I don't know the exact actual. I then asked, were you aware the warrant or the case was eventually dismissed? Answer, I'm not certain, sir. My question, so law enforcement officers do not have a search warrant, though at that time, this is simply an arrest warrant. Answer, correct. On page 33, which is what the state is trying to hijack, to use your word, Your Honor, this motion is transcript and wrongly mislead the parties on what it says. The trial court, Honorable Judge Newkirk, on line 14 states, all right, no other evidence, brief argument. The Honorable Mr. Bailey, then District Attorney in Fulton County, said, Your Honor, the defendant has filed this motion through his attorney, Mr. Steele, challenging while seeking to suppress evidence in this case that was collected from Mr. Williams' home at the time. The basis of this motion is, and the Honorable Court interrupts, the only thing he's challenging is marijuana, which is what the state seeks. Mr. Bailey says on line 23, right. The basis of the motion, thank you, Judge, the basis of this motion is essentially that, in the motion filed by defense, that law enforcement officers did not have the right to enter the home, did not have the right to enter the home to effect the warrant. Going down to line 3, it's on page 34, continuing. Mr. Bailey, the district attorney, on page 3.
Interrupt just a second.
Of course.
IT is about to create a new secure Zoom link. It's only for the attorneys. You're not to share the link. You understand?
Yeah, this is because of that's why the screens are off right now, because of the fun little OnlyFans interlude that happened in the middle of court.
Good? Okay. I'm sorry. Continue.
That's okay.
Apologize.
On page 3, 34, Your Honor, of Court's Exhibit 2, line 3. This is Mr. Bailey, the district attorney at that time, or senior assistant district attorney. On page 3 of the motion, it states, Mr. Williams was arrested on a DeKalb County warrant. However, law enforcement officers unlawfully entered and searched Mr. Williams' home, even though they were supposedly armed with an arrest warrant, and there was no need to search or even enter Mr. Williams' home in an effort to serve this alleged arrest warrant, as there was no lawful reason to force entry in Mr. Williams' home. Then there are two parts here. And that's the long and short of it. Did they, meaning police, have the right to effect the arrest warrant? And what did they see once they got inside that would rise to probable cause? Then skipping, Your Honor, to line 21, the same page 34, this is Mr. Bailey again. Normally, officers can't just walk into folks' homes. That is well established, but there is a carve out for affecting. Officers have reasonable belief the individuals inside. So it is not this way the state is saying that it's only somehow marijuana. I challenge the entry into Mr. Williams' home. When law enforcement went in the home, they allegedly found marijuana, guns, other contraband, and that's when eventually the seizure of all of Mr. Williams' electronic devices that I've challenged, that should have been returned, I've challenged, cannot be used in this case. On page 35, the district attorney said at the end of line 1, Your Honor, or it's the middle of line 1, an arrest warrant found on probable cause implicitly carries with it the limited authority to enter a dwelling in which a suspect lives when there is reason to believe he is within. We have state is saying. The entry into Mr. Williams' home was unlawful. He has his constitutional right to violate. He's a victim. The court should say respectfully, no way, this was litigated. On page 36, the district attorney continues. It's on line 10, Your Honor, and the parties. Now, were the facts that they knocked and he came to the door, and they, meaning the police, Your Honor, detained him, meaning Mr. Williams, then Mr. Steele would be completely correct, and they could not enter the home. They affected the arrest warrant. Then skipping to line 19, Your Honor, page 36. So they have all clear lawful authority, talking about the police, to go in to affect the arrest warrant. And then we get to the second point, and it is in the same Wall case. Wall is W-A-L-L. It states on the last page, once inside the apartment, the law enforcement officers had the authority to seize marijuana that was in plain view. I challenge that law enforcement had no right to go into Mr. Williams' abode. And then the prosecutor on page 36, line 25, concludes, that is exactly what we have in this case. Once law enforcement is inside, they see marijuana on the coffee table in the master bedroom suite, and additionally marijuana on the nightstand in the master bedroom, and Detective Gaither further testified there were guns located in the living room. So that is, I challenged, I had a hearing, we won the hearing, it was a final judgment, not appeal. I am not respectfully required to do it again so the state can bring their A game, lose, and then bring their A plus game and try to win before this court. That's not the way, I don't get to do that, ever.
But it wasn't appealed. I mean, there wasn't, Judge Newkirk's ruling could have been appealed by the state, or could have been appealed by you within 30 days of the entry of the order.
Why would I appeal it?
Well, no, you wouldn't appeal it. But
And the state doesn't appeal. What does that mean? It becomes final. The court cannot amend that order. You'd be amending the finding between the same parties on the same exact issue. They don't get the second, in the case law, it says second bite of the apple. Then, Your Honor, on page 38, line 14, this is the district attorney again. So it's just not an issue that makes any distinction or any difference. It's clear here that it's clear here they, meaning the police, had authority to go in to effect the arrest warrant because Mr. Williams wasn't outside the house and he didn't come to the door. Once inside, law enforcement saw illegal contraband drugs, that is probable cause to get a search warrant all day long in any jurisdiction of the state. Your Honor, the police had no right to enter. That ruling was made. I then say on page 39 of the same Court's Exhibit 2, line 1, I get to speak. The court gave me an opportunity to speak. I said, thank you, Your Honor. Your Honor, we are traveling under, I'm assuming the court has it. If not, we'll get you a copy. There was a supplement to motion to suppress, and this is what I'm stressing, sir, the Honorable Judge Glanville, any and all evidence located.
All right, so that was a part where it cut out for a bit.
Lawful, and his arrest would be unlawful. And then the fruits of the unlawful arrest may not be introduced into evidence. An arrest warrant was never part of the record below. An arrest warrant not put in evidence was not put in evidence while the witness testified or at any other time. The participants in the suppression hearing refer obscurely to the warrant, the warrant in the case. But there is no document to show that there is an arrest warrant. No judicial officer testified that he or she issued an arrest warrant. If the arrest warrant in existence, no reason whatsoever appears for the state's refusal to put it into evidence in the face of a demand. And I continued, I didn't write, I spoke, page 41, line 1. Mr. Williams demanded in paragraph 7 of the supplemental motion and challenged that there is an arrest warrant. If there's no arrest warrant introduced in the hearing, then we go down the road in kind of an outline. So if there's no arrest warrant before this honorable court, which there is not, then law enforcement officers, according to Sergeant Gaither, 30 or 35 law enforcement officers surrounding his home, Sergeant Gaither, which is G-A-I-T-H-E-R, did not go into the home. However, law enforcement officers entered this home. This honorable court has no evidence that they entered lawfully. Supposedly, he goes into Mr. Williams' bedroom. Now Mr. Williams is outside. So my first issue is the initial entry without the arrest warrants vitiates everything coming afterwards. That was my argument. On page,
I don't know how to say his name. I say Menendez, but I've heard Glanville say Menendez. I don't know. But he's back here like, why are we even arguing this? This is obvious.
42, line 12. I argued to the Honorable Judge Newkirk. So my issue, I said, right, period. So my issue before this honorable court is the first entry. obviously without the arrest warrant at this hearing is unlawful. Then the second can't be saved by the second entry either, because that would be without lawful blessing. Same thing as unlawful search, the second one we're talking about. Then the search warrant issue, this would be my third issue. So first one, no arrest warrant. I am challenging, it is clear to everybody, including when you read the state's motion for reconsideration that I've already entered, Your Honor, at the last hearing, everyone knew I was arguing that the entry into Mr. Williams' home was unlawful, and therefore everything in that home could not be taken, should have been suppressed and returned to Mr. Williams. And the state's reliance on Alford, State versus Alford, the state's reliance on this narrow window that only the Honorable Judge Newkirk suppressed marijuana is frivolous. On page 43, starting line 4, I continued. But then when the court goes through and looks at the search warrant itself, the only way we would have probable cause in the search warrant is if the court finds that law enforcement officers on the day that this happened actually had the lawful right to go in the house and to observe, because everything else in that search warrant does not produce probable cause to search Mr. Williams' home. Then it continues on page 45. On line 4, at the end, I say in the middle of the sentence, nothing is attached showing that this arrest warrant was valid from DeKalb County. On line 40, page 46, on line 5, the next issue, Your Honor, that is asserted is that law enforcement officers entered Mr. Williams' home on the day that we're talking about. And I challenged that in the supplemental motion with the fact that it was read to this honorable court by the district attorney, supposedly armed with an arrest warrant, and there was no need to search or even enter Mr. Williams' home because I'm challenging the arrest warrant was not valid if there is an arrest warrant. And the last issue in the affidavit for the search warrant discusses items that were located by law enforcement officers during the search on the day that you heard about, which I would say is a fruit of the poisonous tree. So I have 3 issues. 1, there is no at all arrest warrant presented to this court. So under Baez, which I have a copy for the court, how can I challenge the arrest warrant? How can the court say it's a lawful arrest of Mr. Williams at his home without being armed with a certified copy of the arrest warrant? Therefore, and I stress this, Your Honor, everything thereafter falls as fruit of the poisonous tree. On page 47 of the transcript in courts number 2, on line 9, I continued. So the only thing we're left with is the unlawful entries into Mr. Williams' home, and I would ask the court, based upon that, suppress the evidence, grant the motion to suppress. Mr. Bailey then speaks on page 47, line 14, and going to line 18. At the last word, he says, this motion to suppress the search of a home that the defense is alleging is illegal. Nobody's talking about only marijuana. Mr. Bailey continues on page 48. In line 10 in the middle, the only 2 questions, Your Honor, are, did they have reason to believe Mr. Williams would be there? And so they could go into the house and get him. That's it. And then secondly, once they're in the house, did they see something that would give them probable cause to obtain a search warrant? Those are the 2 issues, not whether the arrest warrant out of DeKalb County was valid and whether the case was eventually dismissed or anything like that. The court then, on page 49, on line 6, says to the state, in which case you would have produced a copy of the arrest warrant. And Mr. Bailey says, right, which would have been a subject, I'm sure, of the suppression motion at that point. And then the Honorable Judge Newkirk said, well, it sounds like Mr. Steele made the arrest warrant a subject of this motion, also in a supplemental motion, which the court file does not have.
Sound again.
The prosecutor says, and that is the copy, the supplemental one. Again, he's not challenging the arrest in this case. He mentions something in there about the DeKalb arrest warrant. If he wants, there's no need to challenge the DeKalb arrest warrant now because the case was dismissed. But there is a forum for doing that, and that may be what they did in the case. Maybe they challenged the arrest warrant in that case. On page 51 of courts number 2, the district attorney states on line 6, that doesn't mean that because it's not a certified copy of that arrest warrant, that has any bearing at all on whether the entry and subsequent search of this house was proper. Everyone's talking, Your Honor, about the entry. That would be the state's argument in the case. At line 11, the Honorable Judge Newkirk said, all right, Tell me again about Baez. I'm not familiar with it. What is the site? Is it Supreme Court or Georgia Supreme Court? I say Court of Appeals. I give the court the site. And then on line
I'm sorry,
51.
51, okay.
Yes, sir.
Yep.
And then on line, the court asked me for a submission on Baez again, and I said, okay, that's on line 22. So it's a motion to suppress like we're dealing with here. Law enforcement officers have obtained a search warrant after an arrest warrant. So it's the same sequence here. Going on to page 52, Your Honor. Law enforcement officers utilize the arrest warrant. They call it several things, bench warrant, arrest warrant. And just like Mr. Williams, it was challenged whether it was a valid arrest warrant. The motion to suppress hearing goes forward. The prosecution doesn't put forth the arrest warrant. The Court of Appeals says without the arrest warrant, it is not in the record. We are not finding there was an arrest warrant. It was challenged, and they suppress the evidence and find it is a fruit of, since there's no basis in the record to have an arrest warrant, everything thereafter is unlawful. That's exactly what I think happened here. That's why I used the case. Why did I make the supplemental motion to suppress all evidence located from Mr. Williams' home? Your Honor, I was challenging everything. It is clear. And I'll get to the Judge Newkirk's order because it's not a fair reading of the order to say only the marijuana. That's not true. I didn't write that order, by the way. On page 52, line 23, I say, and I don't want to play.
One of the reasons he's saying I didn't write that order, by the way, is sometimes attorneys will submit, a suggested order and make it easy for the judge to sign off on something. And Glanville in particular really relies on the attorneys writing orders for him. We're going to see that happen. He's going to ask Attorney Steele, I think in this video, to write the order for him. And then later on a second issue that we're going to watch, I think in relation to a potential subpoena from Michael Sprinkel that ends up getting quashed. It's not when we see him testify for about an hour before trial. It's a different matter that we didn't actually get to hear about during that. And I forgot about it. I don't remember it. It's actually really crazy what Brian Steele says Michael Sprinkel did with a grand jury without an indictment. But Glanville, when he makes his ruling, he asks the prosecution to draft the order for him. Glanville leans heavily on one side or the other drafting the orders, which I think is really interesting because imagine giving Love the leeway to write an order, you trust it, and you just sign the bottom of it. And then when that order is referenced later in the trial or in a different matter, it's really the words that Love drafted as representing the court's findings. So Love gets to write down her interpretation of what the court orally may have decided. Just think about that. Think about that. It's not uncommon, but I think Glanville uses it more than most. And I have grave concerns about asking Love to basically draft my ruling for me.
Games with anybody. I put it in its own paragraph. I made it a supplemental because I realized there was a problem with the arrest warrant. So I made paragraph 7 standing alone or standing on its own. And I wrote, moreover, law enforcement officers were not armed with a valid arrest warrant in DeKalb County at the time of entering Mr. Williams' home. And thus, and Your Honor, I'm stressing this, all evidence must be suppressed on page 53, lines 1 through 5. Then skipping to line 15, I again plead to the Honorable Judge Newkirk, the law should be followed in this case. And I say, but I guess it goes back to if the first arrest warrant is not before this honorable court, according to Baez, it was challenged, just like I challenged it on behalf of Mr. Williams, then how can this court sit here, the evidence that you heard, and say, well, there's a valid arrest warrant. We challenge that there's no valid arrest warrant, and then it's not saved later, in my opinion, the search, because I don't know how else law enforcement gets in the home. Because now, thank God there's not a shootout in the house where law enforcement had to go there. On page 54, line 5, Your Honor, I continue. So I don't know how law enforcement, without a valid arrest warrant here today, has any evidence to go before the court. And that is why I made an issue of the other items in the search warrant, like the confidential source, the alleged confidential source, the murder of Mr. Thomas, because all of that doesn't save the search warrant. So that's why I thought it was important. The court states, the Honorable Judge Newkirk, on page 55, its ruling. On line 18, the court says as follows. All right, Mr. Steele, I'm going to go with you on this. I think you are correct. I think the burden is on the state to show the initial arrest warrant was valid and initial entry into the house was valid. And he hasn't done that, meaning the prosecutor has not done that. It appears there's no testimony from any officer. Certainly, there's no need for her to go back in the house without a search warrant. It doesn't sound like she searched for anything. So that might have been harmless, excuse me. That might have been harmless error because the arresting officers discovered it and went out and told them. And this is what I'm stressing. Line 4, page 56, the Honorable Court's ruling. But I don't think we get to that hurdle because the lack of authority shown to the court that they had permission, meaning the police had permission to enter the house on the front side. So I will grant your motion, Mr. Steele, if you will prepare a proposed order. I never did the proposed order. I don't know why I wouldn't do that when I'm told. Maybe I did and the judge didn't like it. That's not my order. The bottom line I'm trying to tell this Honorable Court with as much earnest and power and professional as I can is I do not want to relitigate this after I gave a roadmap to the prosecution on how to litigate. If they need me to help them litigate a case, I'm not helping them. The issue here is we had the hearing. I challenged the initial entry into Mr. Williams' home. He is the victim of constitutional rights that have been violated, and the state doesn't get to go back and do it again. Then Judge Newkirk's order. If you look at his order carefully, Your Honor, he does not just suppress marijuana. The prosecution, and they're great people, but on page 33 is all they want you to do, Your Honor. They want you to be in your foxhole and just focus with tunnel vision and say when the judge said all he's challenging is the marijuana and act like, well, that's all there was. The judge found that the entry was unlawful. We don't get to do it again. And Mr. Williams then tried for a year and a year to get back his property. And what did the police do? They tell him, it's the evidence. We're not giving it to you. The statute says it. And now today the state wants to come in and say, well, we had another search warrant. I will talk about that search warrant in a moment. Let me just show you, if you don't mind, the order of the Honorable Judge Newkirk, which I forget the number.
It is D4.
Looks proud.
And Your Honor,
That's the first one.
thank you, sir. And it's entitled, it's filed, I know the hearing was on the 3rd of April, 2017.
Filed in on the 11th of April,
Right.
2017.
So D4, order granting supplemental motion to suppress, and I'm stressing it, any and all evidence located from defendant, excuse me. It's Mr. Williams' home. It says it's used defendant's home. After hearing testimony, a stipulation of testimony, and argument from the parties on Monday, April 3rd, 2017, this court hereby grants defendant's supplemental motion to suppress any and all evidence located from defendant's home. There is nothing clearer in the world of what was suppressed. The prosecution is intellectually not being straight. Based on this ruling, meaning everything's gone, the evidence located in Mr. Williams' home that is subject to this accusation. That's all. The accusation was just a marijuana case. Specifically, just over an ounce of marijuana is hereby suppressed and cannot be used in evidence by the prosecution in the trial of defendant Williams. Do you know where the judge got that language from? I know I didn't do this order because I would always say the Honorable Court. This is just not the way I'd write an order. But you know where the court did get?
Oh, that's a little funny, right? We know that he got to a point where he didn't address Glanville's court as the Honorable Court. But alas, this is back in December of 2022.
The language of what the state was relying, specifically just over an ounce of marijuana, it's in my motion. I said suppress everything, specifically including the marijuana. It is not true what they are telling this Honorable Court, and that's not acceptable. Then you go to the search warrant. The state wants to rely on a search warrant from 2016. It was signed by the Honorable Judge Woodson. It is signed, and it's in your court's file. I believe it's defendant's number 10. I'm going to tell this Honorable Court. And it was signed on June 27, 2016.
I have the warrant for search and seizure as D10. You introduced that last time.
So, Your Honor, this is the same items that were taken from Mr. Williams' home in July of 2015. It's the same exact items that should have been returned. The state of Georgia has a search warrant. What they don't tell you, and I'm not saying they're hiding it, they just didn't tell you, is that they couldn't get into Mr. Williams' devices. They sent it to Cellbrite with the search warrant, and Cellbrite wrote back, and the GBI, we can't get in the devices. The search warrant then is never applied for again to tell any court, like this court, by the way, there was a hearing and all the evidence was suppressed. The state is using then in May of 2017, after Judge Newkirk suppressed the evidence in April of 2000.
Do you see the play? Let's rewind and listen to Steele's order of events. Evidence is suppressed, and the state is still using that same those same devices, the device that they were supposed to return, it was suppressed. They're not supposed to use it. They're going to a third party and asking them to extract the material from it. For what purpose? What would you need to extract it for? Like, this is wild.
And it was signed on June 27, 2016.
I have the warrant for search and seizure as T10. You introduced that last time.
So, Your Honor, this is the same items that were taken from Mr. Williams' home in July of 2015. It's the same exact items that should have been returned. The state of Georgia has a search warrant. What they don't tell you, and I'm not saying they're hiding, they just didn't tell you, is that they couldn't get into Mr. Williams' devices. They sent it to Cellbrite with the search warrant, and Cellbrite wrote back, and the GBI, we can't get in the devices. The search warrant then is never applied for again to tell any court, like this court, by the way, there was a hearing and all the evidence was suppressed. The state is using then in May of 2017, after Judge Newkirk suppressed the evidence in April of 2017. The state then sends Mr. Williams devices when they won't give it back to him. They won't restore it to Mr. Williams or his father, who had a power of attorney. They go to Cellbrite, and Cellbrite now has better.
All right, so it cuts out. We don't get to hear if he's whatever he's arguing about. I didn't jump ahead, so I don't think it's quiet for too long on this part. But we do miss, and he looks like he's making a good point here.
Open the items. They don't get another search warrant. The legislature then says at the last 3 lines of this code section, Your Honor, any search warrant not executed within 10 days from the time of issuance shall be void.
Mr. Steele, go ahead, sir. Okay, go ahead, sir.
17-5-25, the last sentence that the legislature taught us. Any search warrant not executed within 10 days from the time of issuance shall be void and shall be returned to the court of the judicial officer issuing the same as, quote, not executed. The state doesn't have a search warrant in 2017 in May. They steal Mr. Williams' property. They illegally enter his home. They steal his property. Then they keep it, the stolen property. They keep his the property they stole. And then they go to Cellbrite and they ask him in May of 2017, after everyone's on notice that the motion to suppress was granted, not even appeal. They didn't have the guts to appeal. And say
they didn't have the guts to appeal. Love it. Love it.
In May of 2017, after everyone's on notice that the motion to suppress was granted, not even appeal. They didn't have the guts to appeal. And say break into the devices. I mean, what are we doing here? And they want to do it again. I respectfully ask the court to enforce the collateral estoppel, res judicata, law of the case. It should have been restored. The police should not have had that evidence. It should have been given back to Mr. Williams. He shouldn't even have to ask for it. And I think that State versus Alford, I'm sure the court has read it. It is telling the court something that the case does not discuss. It is just not even arguable that case matters to this. That they had additional reason to go into the home, into the car in Alford. They had the automobile exception. That is my argument when you ask me. I hope I answered your question. And I think if I'll answer any other question, but I hope I answered your question.
You did, sir. You did. Ms. Rossenwasser?
Your Honor. Quick context here. This might be a new face for some people in the chat. I would say, good to see you here, Serena. If you tuned into the YSL trial while trial was already in progress and you missed these pretrial hearings, this was I think the senior assistant district attorney. She ends up, this is again, December 2022. This is like a week and change before they drop all the plea deals in front of the co-defendants named in this indictment that have been denied their bond hearings despite multiple requests. Well, she announces her departure. Her departure is announced in January of 2023, and she leaves before the end of January 2023. So she's jumping off this boat shortly after this hearing. And did I say her name? It's Lizzie Rossenwasser.
I know Mr. Steele has an interpretation of the language of the order.
I think that his interpretation is right. I'm just gonna tell you that. I mean, I look at the way it's capped, its style and everything else, and it makes sense with what you're asking me to do is kind of just narrowly kind of look at the marijuana and not anything else has been seized. He challenged everything that was taken at that particular point in time. And it's clear in the transcript that he did in fact assert the through the poisonous tree. I mean,
So, Your Honor, if I may, when I looked at this case first and I saw his motion, I was sort of thinking the same way as the court. And then I thought, I'm going to check the case law. I'm going to check what the actual order says. And when I looked at the order, that's when I started thinking it might be something different. And whether or not we interpret it a certain way, the language itself, the plain language, and I know that the directive from the appellate courts has been to look at the plain language of statutes, to look at the plain language of orders. The language itself says, the evidence located in defendant Williams' home that is subject to the above referenced accusation number, specifically the just over an ounce of marijuana. If the court had intended to suppress the remainder of the items after just stating, so the court says, the court grants defendant's supplemental motion to suppress any and all evidence located from defendant's home. He could have just said that, and that would have been a different ruling. But instead, the judge then said, based on this ruling, the evidence located in defendant Williams' home that is subject to the above referenced accusation number, specifically the just over an ounce of marijuana, is hereby suppressed. If the court wanted to make a ruling on the fruits of the poisonous tree, it could have, but it's clear from the transcript. And I'm not going to say Mr. Steele didn't argue about that during the hearing, but he didn't ask the court, hey, Judge Newkirk, can you please make a ruling on the fruit of the poisonous tree? There was no ruling on fruit of the poisonous tree. We're not talking about
Steele. Look at Steele in the back.
There was no ruling on fruit of the poisonous tree. We're not talking about a second bite of the apple here. We're talking about him now challenging a search warrant that was not challenged before. And I think
though, that's the thing about it. I mean, I think it's clear from reading the transcript and the exhibits 1 through 10 that were admitted when we were here on the 17th of November that he challenged everything: the arrest warrant, the search warrant, and he, in fact, he filed a supplemental motion to that extent. So Judge Newkirk granted the marijuana was only the subject matter of what you prosecuted for at that point in time. You had other things that were seized. Those things are fruit of the poisonous tree, or the minimum should have been returned to Mr. Williams.
And so, Your Honor, I do want to pivot that if this court right now today says, hey, I'm wrong, and Your Honor finds that the cell phones are fruit of a poisonous tree, now and only now would Mr. Williams be able to demand his cell phones back. There has never been a ruling on the cell phones until this day. And I think that's really clear from the court's language in the transcript. Specifically in the transcript, the court says, and this is in the court's ruling, and Mr. Steele actually read it, it says we didn't get to that hurdle. So this is on page 55 to 56. The Judge Newkirk says it doesn't sound like she searched for anything. So that might have been harmless error because the arresting officers discovered it and went out and told them. But I don't think we get to that hurdle because of the lack of authority shown to the court that they had permission to enter the house on the front side. So I don't think we get to that hurdle. There is no ruling on fruit of the poisonous tree. There was no previous ruling on the cell phones. To the extent Mr. Steele wants to make an argument about the other search warrant in the other case, that other search, we can do that today. We have the witnesses here. If this court can make a ruling whether that search warrant was proper. And we have testimony. We will explain the delay. We will explain that there was not the appropriate software available at the time of the warrant. We'll explain why all that was lawful. But there's been no time to litigate that. The question now is whether there was a previous ruling on the fruits of the poisonous tree, and Your Honor, there just wasn't. And Your Honor, we have here the law enforcement, I do mention this briefly in my case, there was no finding that his rights were violated. There was a finding that the state did not meet its burden. Here, the officers acted in good faith. Again, we are prepared to show that there were proper warrants for everything. We haven't had that opportunity yet to show as to the 2016 cell phone warrant. We're ready to do that today. Now, Your Honor, there has just been absolutely no ruling as fruits of the poisonous tree. And if the court were to find
This was the most welcome audio cutting out. So it was out for about a minute this time. So we don't have a minute or so of what she was arguing, of what Rossenwasser was arguing on the state's behalf here. But, oh my gosh, doesn't this sound lovely? Holy moly.
And it says,
Absolutely.
except as provided in,
Shout out to lead attorney.
17.555 or 17.556 subsections D, E, and F. And it goes on to say, When a final verdict and judgment is entered in finding the defendant guilty of the commission of a crime, any personal property used in evidence in the trial shall be returned to the rightful owner. All personal property in the custody of a law enforcement agency, including personal property used as evidence in a criminal trial, which is unclaimed after a period of 90 days following its seizure or following a final verdict and judgment in the case, property used as evidence, which is no longer needed in a criminal investigation or for evidentiary purposes in accordance with 17-5-55 or 56 shall be subject to disposition by a law enforcement agency. So this one is different, different than 17-5-30, which is pre-trial. So this is trial evidence, what we do with evidence after the trial of the case. So that, and I mean, I still have an issue of that because you would have still had to return his property to him.
Your Honor, I'm sorry. I have to respectfully disagree with the court here. It's not a situation of what Mr. Steele.
Oh man, okay, we were here. Look at Glanville's.
Back anyways, he wouldn't get.
I just messed it up because I clicked at the wrong spot. I think I screwed us up. I think I went, I don't know. I think I went to where it was buffered.
Or following a final verdict and judgment in the case, property used as evidence, which is no longer needed in a criminal investigation or for evidentiary purposes in accordance with 17-5-55 or 56 shall be subject to disposition by a law enforcement agency. So this one is different, different than 17-5-30, which is pre-trial. So this is trial evidence, what we do with evidence after the trial of the case. So that, and I mean, I still have an issue of that because you would have still had to return his property to him.
So the reason I tried to pause before I messed up the scrubbing is when Rossenwasser starts speaking and makes her first counter argument, watch Glanville's eyebrows in disbelief.
Your Honor, I'm sorry. I have to respectfully disagree with the court here. It's not a situation of what Mr. Steele challenged.
Very subtly, his eyebrows, as soon as she says she's challenging him, his eyebrows sink down.
At the previous motion is what was ruled upon. There was no ruling upon the.
So if I had $200 and this situation happened, you wouldn't have to return the $200 to me if I won my motion to suppress?
Your Honor, if I had a search warrant that was valid, currently being executed for your $200, and it was for a separate investigation, a separate case, my position is that no, I would not have to return it until that separate investigation, that separate case was done because I had a valid search. And obviously,
do you have some case law that interprets 17-5-30 in terms specifically the possession of which is not otherwise unlawful? Because that to me says that would be any contraband, weapons, or things that you're not required to, not allowed to otherwise possess. But it doesn't distinguish on investigations or you holding on to evidence that otherwise should be returned.
Your Honor, I don't have a ruling a case at this time. I'm happy to provide that in a supplemental filing. But again, my understanding of the law is and has been that where there is, if a search warrant is currently being executed on a cell phone, for instance, the police are allowed to retain that property as part of an ongoing investigation.
But he won the motion to suppress.
On the marijuana case, Your Honor, not.
But you took more than the marijuana. He wouldn't get the marijuana back anyways. He wouldn't get any cocaine that came back anyways. He wouldn't get a gun back if he's a convicted felon. But anything else that was proper, that was taken from that particular, house subject to the warrant, is not otherwise illegal, is returned. The 17-5-30 says shall return and not be subject to further prosecution, because that's the whole thing about it is you don't get another bite at the apple based on this particular evidence. You can go ahead and do some, a separate investigation or whatever, but this evidence is supposed to be returned to the defendant.
Your Honor, our position remains that because there was a separate ongoing investigation for which a valid search warrant was in effect, and it was not, there was no ruling as to fruits of the poisonous tree, there was absolutely no reason to return that cell phone. I'm happy to provide the court with an additional brief, but that is our position at this time.
Okay. All right. I'm going to take 5 minutes, okay?
Thank you, Your Honor.
Okay. All right. We're going to be in recess for about 5 minutes.
I hope my little editing narration here is hilarious, right? I cut that real good. And he says, we're going to take about 5 minutes, and then skipping about 52 minutes is when we come back. The old Glanville comfort breaks.
Your Honor, we just asked if we could just admit it as a separate exhibit to this hearing. It's certified. It's self-authenticating.
Well, it's already in evidence. And the last one is already in.
Well, any objection to that one, the search warrant, arrest warrant, I should say, Mr. Steele.
I will lodge an objection, at this point. Yes, sir.
Basis?
Basis is that it is attempting to relitigate something that should have been done before. It has no bearing on this motion, whatsoever.
Your Honor, we would like a complete record. And if it's already, as Mr. Steele says in the record, we don't see the harm in simply perfecting the record with a self-authenticating document.
At the hearing in 2017, that was the basis for the ruling for Judge Newkirk. So I don't see why I would need to accept it right now. Because I'm going to rely upon Judge Newkirk's ruling.
We just like to have it in the record, so we may use it just to complete the record, Your Honor, not for the purposes of argument in this particular instance. Should the court wish to rule with us and have a hearing on this, then we'd enter it separately, but for the purpose of the record, we'd seek to introduce it right now.
Let me see it, please.
Yes, Your Honor. It's certified.
All right, Mr. Steele, I'm going to admit over your objection, okay? It states one for purpose of the motion.
And Your Honor, then we'd also just move to admit a certified copy of the search warrant to enter the defendant's home. This was actually attached as an exhibit to the previous transcript. Again, we'd just like to admit this for the purposes of perfecting the record. It's a certified copy.
Okay.
I'll object. It's attached as court's exhibit number 2, pages 57, 58.
Oh, the transcript. The transcript was admitted, Your Honor, but we'd like to admit the certified.
All right, certified copy. States 2 for purpose of the motion?
Yes.
Okay, all right.
As Mr. Steele stated, the other was E10.
Yeah, I've got, that's admitted already.
Is that certified, Mr. Steele? No.
But it was admitted in the hearing on the 17th of November.
May we also tender this as a certified copy of that search warrant, though? As states 3.
All right, any objection? Or same objection, sir?
Yes, sir.
Okay, all right, states 3 is admitted for purposes of the motion.
Thank you, Your Honor.
Anything else? Anything else in terms of the states and states 1, 2, or 3 for purpose of motion?
Well, Your Honor, we would ask to have a hearing to have the opportunity to show that lawful entry. We weren't sure if the court was going to allow us to do that, but if we are ready to do that, we'd like to do that.
I'm not inclined to have a hearing on this, okay? Because, and here's why. Judge Newkirk's ruling.
Now, I know the audio's been bad in court, but my ears have been saved for the most part because something else has been largely absent. We have Glanville saying here he doesn't want to have a hearing on this matter. So what's the theme of this reunion as of late? What do you think their next move is going to be if we're not going to do a different hearing on this, even though the judge already decided?
Fairly contains some principles of criminal procedure, and even though you've admitted these particular items for purposes of the record, which would supplant bias and some and would make the issue of your, that's one argument you could make in terms of the sufficiency of the arrest warrant and the search warrant. The issue still becomes is that that issue was decided by Judge Newkirk earlier, and you all from the state have not given me any. You're still not getting over 17-5-30. There still would be no reason for you not to have returned this property. There's nothing in law that you have the right to, to maintain and continue to investigate on those particular items that were taken. But so that's why I don't need to have a hearing necessarily on it, on that particular issue. So with that,
Your Honor, the court permit the states, we would like to proffer what the evidence would show, where we permitted to introduce the witnesses that we have as the court.
I'm okay with that. I'm okay with you all. But I mean, the warrants would supplant the certified copies of the warrants that you have at this point in time would supplant Mr. Steele's argument. But the problem that you're going to have is that 17-5-30 would have required you to still return that particular property. There's no case law which indicates that particular issue, and the statute is pretty clear. It says, motion, if the motion is granted, because Judge Newkirk granted that motion, and it shall not be admissible against evidence of movement in any trial. So basically, you're getting a second bite at the apple, and that in that particular circumstance, that's why the legislature makes some very specific issues about 17-5-25, which is execution warrants, 17-5-30, which is motions to suppress, and then 17-5-54, which is different. That's trial disposition of property. So in that respect, that's why in this particular circumstance, you all still, now, if you've got another argument as to why you didn't, other than why you didn't return his property, but you would have still needed to return it. I mean, you didn't go forward with that prosecution. If you've got some other case law you want me to look at, but it's pretty clear. The reason that the legislature did this, enacted this statute, is because they didn't want the state. Yeah, and Mr. Steele's argument is, and just hear me out, you didn't have a valid arrest warrant to begin with. Now you got one, but you didn't have one when you had one from Judge Newkirk. You sought a search warrant, so you weren't in the right place and space to begin with, because you went in the house, somebody saw some marijuana, or somebody saw whatever it is, and they, in D10, they got they drew an affidavit, and they said, okay, we want to search the house. Well, you got to be in the right place and space to begin with to have the authority to search the house to begin with. Mr. Steele, in his motions, asked for suppression of anything that was taken in the house. So marijuana and anything else that was the basis of that. So that's fruit of the poisonous tree. He's argued that all throughout his motion. He's argued that. And so Judge Newkirk, by implication, had to consider it as part of his ruling. So you're asking me to kind of, okay, well, the marijuana's over here, that's fine, but he didn't suppress the other stuff, we can still use it. That's not the way I interpret this particular scenario and interpret the law related to search and seizure of this particular item.
Your Honor, thank you. And respectfully, the issue of whether or not the state had a valid arrest warrant is actually proven with respect to, did we have one with the certified document that the court has that the state has tendered as evidence. So it's not a matter that the state did not have lawful authority to enter into the home.
But you didn't have it at the time that Mr. Steele.
We had the search warrant. That search warrant, that certified document that is in evidence, Your Honor, has a date on it. It was signed and filed well before Mr. Steele made that motion, and it was a part of the record of the first report.
The challenge is you all didn't take that up on appeal or anything, ruled upon by Judge Newkirk.
Your Honor.
So at this point in time, is it fair to Mr. Williams for you to have another bite at the apple? I mean, at this point, because you're asking me to go ahead and let you use this particular evidence that arguably another one of my judicial colleagues has said, hey, despite the fact that we disagree about how the motion has been styled, clearly it would be subject to being suppressed.
And Your Honor,
and even if I agree with you, okay, let's say you corrected all that. 17-530 is still fatal to you. You still would have needed to return the property. And you haven't given me any legal justification for you to keep that property and continue to then investigate that property or search that property. Unlike trial evidence. Trial evidence is clear you could have done that. 17-530 is distinguishable because it's like the legislature seemed to indicate, well, we don't want the state to go ahead and continue to keep investigating an individual based on evidence that a court has suppressed. So that's kind of where I am.
Your Honor, if I may, the distinction is that there was a good faith basis for obtaining the search warrant and for getting the search warrant. A search warrant affidavit for the home itself was sworn out. There was, in fact, an arrest warrant that did exist. It was lawful. The fact that there was not one presented in the 16 SC case is what, yes, caused Judge Newkirk to suppress the evidence as to that case, Your Honor.
Okay, and why didn't you return the other stuff to Mr. Williams? You wouldn't have had to return the contraband. Everybody's clear about that. Contraband or weapons would not have been returned to Mr. Williams. Why didn't you return any of the other stuff?
We had actually sought the search warrant, Your Honor, and I think that the court can look at the dates on the search warrant, on the arrest warrants, and see that we had actually already received lawful authority to search. We had already sought and obtained a search warrant for the items. We had already obtained what the state believed was lawful authority.
If Judge Newkirk has already suppressed the marijuana on that under the same analysis, okay, then why wouldn't the rest of the stuff that you took be suppressible at that point in time and free the poisons?
Again, the ruling by Judge Newkirk came after the state sought permission to search the items. So we had what we believed to be lawful authority to search the items, the search warrants that were obtained. And we have witnesses that will testify.
Assume I believe you, okay? Assume I believe you.
Yes, Your Honor.
All right. Still, Judge Newkirk grants the motion to suppress. The case is over. You can't proceed on the 16 SC case anymore. The evidence that you all took, why didn't you return it?
Because, Your Honor, at that point, we have, from sources, we have probable cause to believe that within items located within Mr. Williams' home, and this is separate and apart from the fact that he possessed marijuana, but at this point, we have information independent of that to believe that within his home, we would find evidence of these other crimes that we were at that point investigating. Prior to Judge Newkirk hearing the motions, prior to Judge Newkirk issuing the order that he issued, even if the court were to see it as more expansive than the state believes that it is, we had probable cause based on information and sources independent of the fact that the defendant had marijuana or firearms or whatever it was that was seen when the officers initially entered the home to execute what was and what is. It doesn't change it. The fact that the arrest warrant that was in existence at the time actually was valid and gave them lawful authority to enter the home does not.
Judge Newkirk ruled that you didn't have that at that point in time, because at the hearing that you had in front of him, or the Mr. Bailey represented you all on the 3rd of April of 2017, that was, you didn't have that particular certified copy of the arrest warrant. And so Mr. Steele, by argument, says, hey, look, I'm extending my motion. I'm going to include everything that's in the house because you weren't validly in the correct space and place. Now, had you had that search warrant at that point in time, or not search warrant, but the arrest warrant valid at that point in time, then Judge Newkirk would have probably said, okay, well, then you're fine. But that wasn't that, these particular scenarios have to be ruled upon in terms of what the judge has at that point in time. So if you look at that, even if I accept, which I have, I've admitted, states 1, 2, and 3, you still have to return the man's property. He's asked for it to be returned. He hasn't had it returned pursuant to 17-5-30, because I can't go back and unring the bell in terms of Judge Newkirk's. You're not saying Judge Newkirk's ruling was erroneous, are you?
I'm saying that Judge Newkirk's finding was that we had not presented a certified copy of the arrest warrant, which is not the same as that there was an unlawful search and seizure. It's just that the state had not tendered.
On 3 April 2017, that's exactly what he was doing. Okay, so you're asking me at this point in time to say, hey, Judge, we can correct that. On December the 15th of 2022, you've introduced states 1, 2, and 3 certified copies of the arrest warrant, the return of search warrant and inventory, and the affidavit for search warrant. And that's why I'm telling you, assuming that that is now corrected, the problem that you still would have is the return of property under 17-5-30, because you took the marijuana and the other pieces of evidence from Mr. Williams' home. I don't think the law distinguishes between that. You would have had to return that. You still would have to return the property to him. So, because at this point in time, he's entitled, or he would have been entitled. He's asked, and Mr. Steele has already introduced from in the last hearing on the 17th. He's asked me, or he's introduced a letter that he sent to Mr. Bailey saying, "Hey, I want the evidence back."
Your Honor, but the court did not rule that evidence. Number one, there was no ruling as to that.
I disagree. By implication, Judge Newkirk had to have considered the fruit of the poisonous tree. Mr. Steele asked him to do that. And it's a snapshot in time. So on the 3rd of April, 2017, you didn't have what you have now. And so you're asking me to correct something that is arguably, can I do that? I mean, even if I can, that still runs afoul of 17-5-30. You still would have had to return Mr. Williams' property. And then Mr. Steele asked you for the return of that property. And there's no exception under 17-5-30 pretrial that gives you the ability to keep the property. You have to return the property. The property that, and then you took that particular property, in particular his phone, and then you extricated things out of it, which would be tainted or fruit of the poisonous tree, because you didn't have the right to keep that. You didn't have the right to keep that particular evidence under 17-5-30.
Thank you, Your Honor.
All right. For purposes of Mr. Steele, you can prepare an order, okay? Sufficient to recap what the court has indicated. Now, I know that puts us in a position where some stuff that you may have the state was going to admit or utilize Does that change your position, ladies and sir, about where you are with what would be admissible in this particular prosecution?
Your Honor, there are affected by, of course, suppressing the evidence that was seized back in 2015. There are some items that we believe may have more evidentiary value than others. And so it does affect the evidence that the state intended to introduce in this case.
Well, I was just asking because if you need to sit and talk with Mr. Steele about what you can agree that would be not admissible at this point in time, given my ruling.
Through an order from Superior Court at the request of the former district attorney, they contended that the seizure of their records without probable cause was a violation of their Fourth Amendment rights and that the records should have been suppressed. The court in Kessler found that like bank records, telephone, toll, and building records are not owned or possessed by the defendant, but are business records belonging to the telephone.
So just in case, because of the jumping with the feed being patched together, this is a related, but it's a separate argument. So Brian Steele also moved to suppress records, not the extraction from the device itself, but records from the phone company. And the state's going to argue, well, that there's a standing issue here because the owner of those records is the cell phone service provider.
Company. The court further stated that the cases cited by the defendant, United States versus Baxter, Katz versus the United States, recognize the right to toll and billing records of the telephone company. The court went on to say that neither defendant, as one user of the telephone, nor the other defendant, as its lessee, had standing to object to the production of these records by the telephone company. Further, Your Honor, REGISTE.
One more time, REG what?
ISTE.
Okay.
Versus the state. And that is 292, Georgia 154. That is directly on point with what we have at hand. As an initial matter, telephone billing records are business records owned by the telephone company, not the defendant. As a result, defendants generally lack standing to challenge the release of such records under the Fourth Amendment because they do not have a reasonable expectation in records belonging to someone else. And that's a pen site of 249 Georgia 462 at 469. Accordingly, the court held that the appellant was not entitled to challenge the release of phone records, in this case, on Fourth Amendment grounds. Your Honor, the issue of standing has to be addressed before the court, given that the defendant has no reasonable expectation of privacy in the cell phone records of the Hertz Corporation. He has no grounds, no standing. He has nothing that permits him to come in and argue that the court should somehow find that the state's method of obtaining those documents was somehow improper. Additionally, Your Honor, the documents were turned over to the state by the Hertz Corporation. If the Hertz Corporation wanted to contest the release of its own documents, the Hertz Corporation and only the Hertz Corporation, and all
like
that they released, I would also make clear, it's not at all anything comparable to information contained in cell site location data that a person has within a cell phone that is deep on their person and that moves around with them. These documents are simply documents that show that the defendant rented from Hertz a particular vehicle at a particular time and returned said vehicle at a particular time. There's no location information data to which the defendant could in any reasonable way have a reasonable expectation of privacy. Additionally, Your Honor, again, the records do not belong to him. He has no standing, no expectation of privacy in them, and he is not properly before the court contesting or moving that the court suppress the release of Hertz's own records to the state. So again, as well, Your Honor, the law on standing requires that the defendant show that he has standing, and his claiming that, just baldly claiming that the information sought somehow references or, as he put it, it touched upon the defendant, or information concerning the defendant, still does not give him any standing to argue or ask that the court suppress information lawfully turned over that he has no expectation of privacy in, even if it was unlawfully turned over. He cannot argue that the court should suppress these documents. He does not have standing to move the court to suppress the documents. There is no infraction of any law or code of conduct. There is no incursion on any protected rights held by the defendant. He is.
Yeah, it looks like from Kessler that he has reasonable expectation of privacy in a conversation. He doesn't have the reasonable expectation of privacy in records. Yeah. So is that kind of sum and substance what your argument is now?
Yes, that's an initial matter. Yes, and I mean we will ask the court rule on his lack of standing before we do anything else for this case.
All right, Mr. Steele, what say you about standing? Looks like these are the Hertz records, correct?
Yeah, they're included. That's true.
As an initial matter, I would agree with Mr. Love. Your client does have to have standing.
It's the car
I would agree.
rental.
I would also
record.
tell you that conversations are different than records. So tell me why you think that he has standing to contest these records.
And when the court started to get into this motion, the court actually asked about Mr. Williams' motion to dismiss the indictment and or motion to suppress evidence and derivative evidence based upon prosecutorial misconduct and abuse of grand jury powers. That was filed on November 3rd, 2022. I supplemented that, Your Honor, on November 10th, 2022. It's the same title, but I wrote a supplement to Mr. Williams' motion to dismiss the indictment and or a motion to suppress. It also goes hand in hand, if you don't mind ruling at one time, I believe it goes hand in hand with the Mr. Williams' motion to suppress number 3.
Well, I need to deal with the issue of phone records. That's what you asked me to do.
The Hertz records.
The Hertz records. So let's deal with the Hertz records first. There may be other issues as to the indictment and some other things. Let's deal with that first. Client's got to have standing in order to address that particular issue.
So I raised it twofold. I raised the motion to dismiss the indictment based on prosecutorial misconduct. Records of another company, although we want to assert standing, Maddox and DDOS versus state says that there is no standing in those records. So I will, under the current case law, I'm not waiving the issue, but I'm telling the court like I'm obligated to do of the case law, and Maddox is.
So you would agree the state's proposition is correct?
I would agree,
But you disagree because you represent Mr. Williams. Am I correctly summarize that, sir?
well, it's not like I represent this. I think the law is inaccurate, but the way I'm saying the law today, we have to follow MADDOS versus say 3464 appeal 674 2018. It's exactly correct what Ms. Love said, that there's no standing records of a public corporation when you rent a car. But that really wasn't my issue. That's why I supplemented it, and that's why I did the separate motion to dismiss the indictment. And
Judge,
the reason.
if I may, and I do apologize to Mr. Steele, but I hear him going into the substance of a thing that necessarily relies upon to complain about obtaining the records from Hertz. So I would ask that.
Let me deal as a preliminary matter, threshold matter. If that's the case, the records, your client would not have standing. I would grant the state's motion as to that, as to the Hertz records.
Understood.
Okay, so is there any other basis that you are asking for at this point in time?
Yes.
Okay, all right, what's that?
Okay. So, and the reason I want to call Mr. Sprinkel, if you allow me to briefly profit.
All right, guys, this is something worth listening to. This is a separate matter than the pretrial hearing where Michael Sprinkel took the stand and talked about, why he was looking at a different set of individuals, how he came to look at other individuals and ended up deciding to indict whoever moving forward versus who was initially suspected and arrested. This is a different issue. I don't remember hearing about this issue, but it's crazy. So pay attention.
All right, okay, now, so offers the why you need to call Mr. Sprinkel.
Yes, because I think that's where it starts. So what happened is Your Honor, Mr. Williams is wrongly targeted by law enforcement for 10 years since he's 21 years of age. And during those 10-year period, there's a systematic abuse of process by the people who claim that other people break the rules, and that's the District Attorney's Office of Fulton County. And what I'd like to call Mr. Sprinkel and prove to this honorable court is as follows. First is what you just heard from. Law enforcement officers and the District Attorney's Office is aware that the Honorable Judge Newkirk found that law enforcement had no right to go into Mr. Williams' home on July 15, 2015, take devices. The prosecution does not restore those devices. You already ruled, I know Judge Newkirk ruled, but that's part of the issues. What right does the prosecution, the District Attorney's Office, have to keep that property and then to send it to self-right without a warrant and have it searched? I want the court to consider that. Then I want the court to consider the following. The fact that the District Attorney's Office did not go back to a judge and say, we have this property, we're supposed to give it back. We are doing another investigation, we want another search warrant. They just go and self-right, I would introduce through Mr. Sprinkel, says, as a courtesy of the District Attorney's Office, we're going to look at this device. I would like the court to have that in its breast when deciding whether there's extreme prosecutorial misconduct. Then what happens is grand jury subpoenas. I'm not moving to suppress anything at this point. I'm not waiving any argument, but I'm not moving to suppress. But this is how the grand jury subpoenas were given out in this case. And it's not only hers. It is every grand jury subpoena. I've attached it to the motion. And what the grand jury subpoena shows is that from his office, presumably Mr. Sprinkel is on every one of these, he has a district attorney seal on the subpoena. The law requires the clerk to seal a grand jury subpoena. Mr. Sprinkel sends all of these subpoenas outside the state of Georgia. There's no authority for a...
indicate which subpoenas he is referring to when he says all, because he...
That it cut out a little there.
Okay, so Ms. Love's argument is, and the court's inquiry review is, what reasonable expectation of privacy do you have or standing do you have in these records?
This is not the issue. This issue goes to dismissal of indictment for prosecutorial misconduct. Mr. Williams was indicted. I'm not trying to suppress the evidence based upon your ruling and the case law. What happens now is there was such egregious misconduct by the District Attorney's Office.
So you're saying you'd like to examine Mr. Sprinkel for his motives for as to why he sought these particular documents in his prosecution.
I want to subpoena, well, I have subpoenas. I want to call Deputy District Attorney Mr. Sprinkel because I want to ask him why he believes he had any right, which I'm contending violates Mr. Williams' rights to due process as stated in State versus Lampel, LAMPL, 296 Georgia, 829. It's in Division 2, 2015 case. It's in my motion entitled Mr. Williams' motion to dismiss indictment and or motion to suppress evidence filed on 11/3/2022. And what the Supreme Court of Georgia held was it is an extreme remedy to dismiss an indictment or account thereof. However, it is a remedy. It's a due process violation. When the state is talking about standing, you can't have more standing than all of these people here who are indicted, wrongly indicted based upon the misconduct of the District Attorney's Office to violate the law and just put us in indictment without this honorable court hearing it. And if this honorable court finds that it reaches the level of outrageous prosecutorial misconduct by the systematic abuse of process by our District Attorney's Office, then the indictment is dismissed. The state is arguing something that has nothing to do with this motion. This motion is not a motion to suppress. It is a motion based upon a violation of due process rights because everyone here, I assume joined the motion, everyone here is suffering from the state of Georgia's unlawful abuse of their power.
What's
That's the
site
issue.
again?
Mr. Lampel's site is 296 Georgia, 892, Division 2, 770 Southeast 2D, 629, 2015. I had the honor of representing Mr. Lampel. Then the state sought certiorari, and that's how the Supreme Court got that case. He's the mayor of tomorrow. Mr. Lampel's the mayor of tomorrow. And that's why I would like to call Mr. Sprinkel, because he's sending out under the auspices of a grand jury subpoena with a district attorney seal, without the clerk seal, outside our state. They've taken evidence from Mr. Williams' home, not returning it, searching it, regardless of Judge Newkirk's finding. And then, Your Honor, what I'd like you to consider, and Mr. Sprinkel would be asked, is a recording in a grand jury And it happens on June 15, 2018. Mr. Sprinkel and law enforcement officers who were present in this courtroom subpoenaed a woman named Ms. Morton, M-O-R-T-O-N. They brought her before the grand jury in Fulton County. They didn't like that she wasn't talking with them. They put her under oath. And they said, it's Mr. Sprinkel is said, I'm recording right at the beginning. It's a 10 seconds of the recording. He says, because in Georgia, it's not an investigative grand jury unless the court deems a special purpose grand jury. It's not federal court where you could do an investigation. The state of Georgia, you need a proposed bill of indictment already against the person and what the charges are. State of Georgia versus Brian Steele, here are the charges. What Mr. Sprinkel tells the grand jury is, this is not an indictment under consideration. We are just here to hear Ms. Morton testify. That's not valid. So I'd like to ask Mr. Sprinkel what right he had to use the grand jury as a district attorney's investigative tool. Those are my five issues. The search warrant, the search of the devices, which already ruled. Why did that happen? Why did the subpoenas come without a clerk? Third one is, why would the subpoenas go outside of the state of Georgia? The fourth one is, why wouldn't you return the property? And the fifth one is, why would you bring a human being before a grand jury when you don't have a real bill of indictment, and you tell the grand jury that this is not a bill of indictment under consideration? What right does the district attorney have? And that's why I subpoenaed the young man.
That's a lot. And again, we are in December of 2022, and Steele just laid out a 1, 2, 3, 4, 5 pathway of how he sees prosecutorial misconduct coming into play in this case. You get this evidence suppressed, you don't appeal it. The order's there, you don't appeal it, the order's final. Then you take the device that you were supposed to return. I go and remind you, hey, you're supposed to return this property back to Mr. Williams. Instead, you end up taking it to Celebrate, ask for an extraction, get an extraction, and then you have your case intake, Michael Sprinkel, running around sending out subpoenas out of state because people don't want to speak to your investigators. So you use the subpoena power of a grand jury, and you tell the jurors at that grand jury panel, this isn't actually tied to any indictment. We just need this person under a subpoena. What? And Love's going to counter argue it.
Your Honor, the defendant still has not addressed the issue of standing as any of these.
He's indicted.
No, Your Honor. The conduct that he is complaining of, he has to have been agreed. He has to have an expectation as relates to that conduct.
I think that's what he's asking me to test. I think that's what he's asking me to test. And he's also saying, hey, he's an agreed person because he's under indictment for these bigger charges. So,
and Your Honor, if I may, I don't know why Mr. Steele cited Glanville in his brief, because it actually supports the state's position in this case. In Glanville, a special purpose grand jury investigated the defendant and subpoenaed that defendant. In this case, it isn't even that the defendant was subpoenaed to testify. He is talking about a person who didn't even yield information that was used against him. He is asserting that actions that he has no right to complain of should be somehow used as a basis for dismissing a lawful indictment against this defendant. So he is, I guess, attempting to leverage the court's ruling previously into something that simply doesn't exist. He does not have a right to complain of the actions he asserts were unlawful or improper. He simply doesn't. And he hasn't addressed his being indicted alone does not give him standing to argue or to complain about the fact that Ms. Morton was taken before a grand jury, or that a subpoena was sent to a corporation or a company or an entity that the defendant has no expectation of privacy in. He simply doesn't get past that initial threshold. And by continuing to fold one argument into the other, he attempts to subvert what the courts
the audio in the court is just like, shut it down when she speaks.
And when the Georgia Supreme Court says, nope, you last standing, being indicted doesn't afford them standing to argue about matters that they have no right to complain about. And so pulled up a whole bunch of matters as they relate to other entities. Frankly, with respect to Hertz or any other entity, they could simply give us the documents we requested them. They could literally email them to us, as some of them will do. But the only entity and the only people that have a right to complain about that, and right now he's skipping over the fact that he has no right. He's asking you to jump right to, let's just get into the substance of the argument. And that is not the way that the law works. Mr. Steele is well aware of that. He is a very seasoned attorney. And he is attempting to escape that fact by just pushing forward and conflating all the arguments and making sure that they collapse into one mud pie. But Your Honor, I believe, and I'd ask that the court address that threshold matter before we get into anything else. And specifically, before we begin bringing assistant district attorneys in to talk about what could constitute work product and to discuss matters that have nothing to do, that are in no way matters that the defendant has a right to complain about.
You shut her down for 5
Mr.
minutes
Bailey,
there.
I mean, not Mr. Bailey, but Mr. Sprinkle, you're challenging by way of the evidence that you were presenting, or that I said you didn't have any standing to see what Mr. Sprinkle in fact did present to that grand jury, what he told them. So
I actually won't do that. What I'd like to do is, why did Mr. Sprinkle serve grand jury subpoenas? Why did he do the process the way he did? I'm not going to ask anything about what happened in grand jury, except I have that recording that was given to us in discovery.
is it discovery?
Yes. Okay. I'm not asking anything about what occurred in grand jury, except what was given to Mr. Williams in discovery by the state of Georgia. It's a recording.
Wes, do we have a copy of the motion? In terms of motion to quash the business records, I'm also going to grant the motion to quash the subpoenas, both subpoenas 1 and 2.
So motion to quash is a win for the state here. So he's quashing the defense's motion to subpoena. They want to get this testimony from Sprinkle. He's quashing it. So state wins on that. They're not going to get Sprinkle on the stand for this issue.
The court is of the opinion that the relevancy of the particular records, but also they're protected by work product under 24-5, 501. And for those reasons, I'm going to grant the state's motion to quash those two subpoenas. All right, anything else?
Thank you, Your Honor.
All right, I have some proffers I need to deal with. Let's see, Mr. Where is he? Mr. Hoover?
I'm sorry, Your Honor. You're hoping we could please cover that.
Yes, any objection, counsel?
No, just because we're not withdrawing the motion, we would just like to argue that on another time.
Shout out to Doug.
Mr. Weinstein, what's your client's name again?
I'm sorry, I'm trying to go.
Well, folks, I'd like to be able to accommodate everybody, but you saw what happened this morning, okay? We had a technology glitch that nobody could have foreseen, I should say.
Technology glitch that nobody could have seen or foresaw, I should say, because a lot of people saw it. A lot of people saw that technology.
And we're kind of a little bit behind, so of just being able to properly conduct court. So, what is your motion? Your motion is to suppress?
Yes, Your Honor.
Could you give me just a few minutes and I can maybe have that motion heard since your witness is here?
No, Your Honor, if he doesn't want her, then we don't expect the continuance.
Oh, okay, all right, so your motion is suppressed. All right, okay, all right, I understand.
Thank you, Your Honor.
I'm with you. Okay, yes. You give a mouse a cookie. What is it you want, Mr. Short?
Thank you, Your Honor. I just wanted to make sure that I respect the record. I know that you have not ruled on the
It's not your turn yet.
Well,
You jump in front of Mr. Steele now?
no, I am not.
Okay, all right. What is it you'd like to tell me?
Well, I filed the exact same motion that Mr. Steele filed.
And
regarding
your client is, sir,
Stillwell.
Mr. Stillwell?
And that
Okay.
was filed on November 16th. And
The motion to dismiss the indictment
motion to dismiss the indictment.
and motion to suppress evidence. You wish to table yours at this point in time?
I have not heard you rule on the actual motion, just on the subpoenas. And I would just point out to Your Honor that our argument is not based on any Fourth Amendment violation that would require standing, but rather the prosecutorial misconduct, which I believe as citizens of the United States, we we all have standing to challenge. And Mr. Stillwell, who has been indicted and investigated in part by illegally issued subpoenas.
Okay.
Okay, well, I just wanted to make sure it was on the record that I too have filed that motion and.
Okay, all right. So to the extent that's been ruled upon, that's fine. Anything else? Yes, Mr. Menace. Well, you probably should reduce that to writing, but Ms. Rossenwasser, if you will include that in order, please, madam. Yeah, I'm going to, in the motion to suppress and motion to quash, okay?
Could you allow me to incorporate Mr. Still's arguments into the record on behalf of Mr. Stillwell as well? So I
Yes, so we'll include you as well. Okay, anybody else? All right. Okay, before I was interrupted by Mr. Sharp, Mr. Hoover.
Yes, Your Honor.
Okay, do you have the issue of the proffer that you'd like to complete at this point in time? I was going to ask you to complete that issue of the proffer, and then also if there's anybody else who we still need to deal with the issue of the proffer.
I'm not sure which proffer.
Ms. Rosenwasser, you want to address that, please?
Your Honor, I believe the court is referring to your continued, Mr. Hoover's continued representation of Mr. Sumlin after you were disqualified as Mr. Blaylock, to see if Mr. Blaylock was on board with you continuing to represent Mr. Sumlin.
Well, Mr. Blaylock's attorney is here, so if the court wants to continue, we can.
Where's Mr. Black's attorney?
This thing, I'm Justin Hill, Your Honor.
Is it Justin Hill?
Yes.
Okay. And you were counsel for, I'm sorry, Mr. Hill, I apologize.
I'm sorry, you said one time?
You're counsel for whom, I'm sorry?
Mr. Blaylock.
Mr. Black, okay, all right.
So there we go. What a time, you guys. I'm also a big part of the motion to suppress arguments from Love. We're only We're only captured in this live replay from the lead attorney with AV to the 7th power as a co-host. So if you want to go and check out their coverage from that day, the link is in the chat and it's also in the description. What I think is really interesting about how these other news outlets, they had these audio issues. They had the Zoom bomb with the guy showing his junk on the court feed. They have to chop up their coverage and re-upload clips to their channel. I think they assumed the argument was said and done after Rossenwasser made her arguments. They didn't realize, their editor might not have realized, hey, actually, this goes on for another 45 minutes thanks to Adrian Love. So even though they did try to re-upload the substantive argument, they just didn't realize that love is love at that point in time. So there's that. Again, that second revelation there, I do not remember. I watched this pretrial hearing on December 15th in 2022. I didn't pay attention to that argument relating to Michael Sprinkel. And I think it's extremely interesting that he's going in and sending out subpoenas, out-of-state subpoenas, trying to get witnesses that won't speak to investigators. He subpoenas them to speak in, he subpoenas one of them to speak in front of a grand jury panel and tells the grand jurors, don't consider this. This isn't actually related to an indictment. We just need a reason to subpoena this witness and get her to testify under oath. Miss Morton. I'm not sure I remember that name, but very, very interesting. Very, very interesting. And again, the biggest reason that we went back and watched all of this is, and chat, you already know, but December 15th, 2022. We have Christmas coming up in like 9 days, 10 days, right after Christmas. What happens? What major events happen in the YSL case? We've got several plea deals offered and signed and rushed to put together, right? We heard a lot about, everyone's rushing to put things together. Versions of the plea deal were changed. There may not have been adequate time to review the changes or notice the changes. Everything starts to come across the table December 27th and 28th and 29th, largely with factual acknowledgments relating to things that my guess they wanted to use something in Jeffery Williams' phone for, but they realized they couldn't after Judge Glanville upheld this suppression. So just crazy, crazy, crazy. And yeah, I think this was a part of it too, Aaron. So there were, I mean, there's like a bunch of pretrial days where you have to go back and see different clips from different stations, even though I remember watching the longer days while they were happening. So I think there's also times where the news outlets were asked or some type of request was made, hey, can you go and cut that out? So Aaron says, according to Miss Sylvia, cameras allegedly got kicked out for a lot of the December 2022 pretrial hearings after a hot mic moment in which the state may have said they'd negotiate with everyone but Thug. And that's consistent with what I've heard. You know, I heard that they didn't seriously offer him a plea, but they wanted to work with everybody else. And again, a key part of those factual acknowledgments from Antonio Sledge and from Tick steered towards implicating Jeffery Williams specifically. So, a list for Mounk Tounk. So the route on the trial court motion that's in front of Judge Whitaker wants them to take the first motion to vacate sentence to the appeals court first, see what they say on that matter, and if and when it becomes necessary, she'll look at the most recent motion that was filed. So there's that. Also, speaking of Miss Sylvia said I think she's going to try to be present for anything relating to the Nicole Fegan, Tincurius Mender, and Brittany Parks indictment that came down yesterday. So, and I think she's been doing everything on her main channel again. So I'm going to link to Infamous Sylvia, but she has a second channel as well. And I always forget what it's called, but it's like similar. It's like a reverse of her name. So there's Sylvia. After she got done covering the Diddy trial, she's been back in Fulton County covering stuff. And let's see. Yeah, Magic City Wings, anyone? Oh, that sounds great. That sounds wonderful. I also want to give a big thank you here. Amy E. had gifted 5 memberships earlier while we were going through the motions arguments. Much appreciated. You guys know we love Amy E. over here. If you know her from Classy's channel and didn't know that she has a channel of her own, she has amazing, just like an archive of so many different things that you can go and watch and check out if you're looking for new content. And if you ever need to try to find like a body cam or some type of release footage, see if Amy's got it. She's doing awesome over there. She posts like something every day. So there's always something to keep you busy. Watch the Rise became a member. Thanks so much for supporting the channel. Chicken Shite with like my favorite profile picture of all time. Laid 5 eggs, making 5 members green. Big thank you to Chicken. And STS, not only gifting 5 when he came in, he gifted another 5. So 10 total new members. Big thank you to STS. And again, this was a pain in the butt to put together. It really sucks. You guys know I love transparency. I love things being streamed. And with this instance, took it for granted, right? I remember watching it live. I started referencing it. I'm like, where's the fruit of the poisonous tree argument? Do you guys remember that? I want to watch that because Love got annoyed and she continued to argue. And we're on our Love-a-Palooza rewind theme right now. And then I couldn't find it. And you guys, thank you for sending in all the different links from these different 5 to 11 minute clips. And again, Lead Attorney had a much longer stream. Somewhere in here, I don't remember exactly where, that technical glitch is in there. Super, super great time over there. Love both their content. AV is covering the YNW Melly trial. Rewinding it. So you guys have heard me talk about Millionaire Mel doing a rewind on YNW Melly. But she's, I think, like 9 days in. AV just started rewatching trial 1. So if you don't want to be in a rush to get caught up, why can't I get to her channel? I always get Avenged Sevenfold. I type AV7 and it takes me to Avenged Sevenfold content. Let's see. Let's get to her YNW Melly. Lots of acronyms here. And there you go. And then have I seen Rotten Mango? I think so. Do they have like a little cartoon type picture? Like watercolory? Maybe not. No, actually, I don't think I've seen this channel unless they recently changed. This is a huge channel. I don't think I know this channel. I think I'm thinking of a random other person that just uses mango in their name. I think I was confused. So this is Rotten Mango, vouched for here by Brooklyn. So I will now subscribe. I see it looks like, let's see, they've recently, in addition to Karen Reed content, it looks like they cover a bunch of different cases, true crime, other issues. So there's another one there recommended by not Chicken, by Brooklyn. And let's see. Oh, eBay Warhol, formerly known as Tracy Fagan, says I'm usually in the bushes. Thank you to whoever gifted me a membership. So love that you are here hanging out in the bushes here with Viverito. Okay, we got another. Good to see you, Ayana. We have a vouch for Rotten Mango here as well. And I don't know, maybe I do know the name. There's a ton of cases that she covers. I don't see any played. If maybe she has an X account, because I feel like the Rotten Mango I'm thinking of is a big account, just not on YouTube. So, and then STS, thank you so much. STS dropping the 20 says, thank you for your excellent work, Kat. Thank you so much. I'm like, oh my gosh, this is so jumpy. And sorry, I know a lot of that, the sound was crappy to listen to, but I think it was an important part of this trial. And a lot of people missed it. And I don't like when things are hard to go back and look and find. I hate when documents are hard to access. I hate when court websites make you jump through hoops just to find the case that you're looking for, let alone start getting documents for it. So anything that I can do to try to keep information available, always happy to do it. So thank you for supporting the efforts here, STS. Super appreciated. Yeah, everyone's like, where's Viverito? And there we go. So yes, we're going to end with Ayanna Davis here. The reminder here, rest in peace to Ozzy Osbourne. Rough week. I've got to call my mom, you guys. My mom loves music, loves Ozzy, was always at concerts, loves Twisted Sister. Every once in a while, if you see me wear a music branded shirt, I don't always wear too much on stream. So I don't want to give the perception that I'm like a avid listener when I'm really wearing the shirt because I think of my mom. But my mom's the type of person, Princess Diana dies, she cried. I remember when I was little, she cried for like 3 days. So I've got to call her to make sure she's doing all right. Very, very sad news. Yes, check in on your local metalhead. Yes, yeah, and Theo. So, yeah, Chloe, sorry to bring you the bad news. Factual Lie, love this. Says, I partied with Ozzy years ago. Love, love, love this. Fatima, good to see you. I think if you rewind a little bit, I think you're going to love the way the court audio just coincidentally cuts off Adrian Love as she's going and going and going. So there we go, you guys. I'm going to go and call my mom. Thank you for hanging out and rewatching something from 2022. Keep in mind, I don't think that this is the end of YSL shenanigans. I've been saying that for a few weeks. With this new indictment against YSL attorney Nicole Fagan and Tancurius Mender and Brittany Parks, it seems like the Fulton County District Attorney's Office doesn't want the YSL case to be over either, because they are naming YSL, the gang, in that indictment and saying that that's the gang that they were doing these activities in furtherance of. So it's never going to end, you guys. So keep the pressure on. Love-a-palooza will continue. I got to see what the next witness that Love examined was. And I might not be able to get that organized tomorrow or Thursday, but put your notifications on. We'll get back together. This weekend, I want to do a Sandra Dorley stream. If you guys remember the name Sandra Dorley, but don't remember exactly why, she's the Monroe County, New York District Attorney. She's still the District Attorney that a year ago, she's driving home. Webster, well, I don't know if it was Webster, but police officer from some department. I'll get the details when we actually go into it. Tries to pull her over. She just keeps driving. She goes all the way to her home, drives for several minutes, pulls into her driveway, pulls into her garage. She doesn't want to pull over for the officer. The officer has to approach inside her garage to, like, what are you doing? This is a traffic stop. And in the in-between, she ends up calling, this is a whole county. She's a district attorney. She ends up calling one of the suburb towns, Webster. She calls their police chief. And she's like, they're trying to pull me over. This is what's going on. She ends up telling the officer that engaged in the traffic stop, last name Crisafulli, whatever, do what you got to do. I'm the DA. I'll prosecute myself. She issues an apology. I did a video on it a long time ago. But more recently, and why she's in the news again, is she's going to be censured. So we're going to see what happens with that. And we also have her deposition transcripts. They didn't depose her until March 2025. So like almost a year after this traffic stop. And in it, she gets into these details like now she's ready to no longer work for the DA's office after she sold her home in Monroe County. Her husband's already moved down to South Carolina, and she's basically saying, I just want to say, before we end this deposition, just let me move on to South Carolina. After she continued to keep her position and work and get paid as a district attorney in Monroe County, New York, this whole time. So it's not like a case of violence. It's a case of audacity, though. Excuse me, a case of audacity. So we're going to look at that this weekend, I think, probably Saturday. And we'll go through the deposition and we'll see how she speaks for herself. And yeah, you guys remember that? There you go. And yeah, let's just pull up a quick body cam image here. Let's see. Yeah, this is a good one. Let me open this image. I think this is a good one. If you've seen this body cam, you'll remember from this still image. This is Sandra Dorley. So, and yeah, she has been deposed already. I don't know when the transcripts were published, but she was deposed on March 25th of this year. So we're going to go through that transcript. It's like 170 pages, but the margins are like this. So I don't think it'll take as long as a typical 100-page document. So we'll do that this weekend at some point. We can rewatch parts of the body cam as well if you guys don't remember this viral story. It was a time. And also, Trakisha, big thank you here posting the link. It's also in the description. Jim, happily angry lawyer, friend of the channel, never met him in real life, would call him a friend anyway. He's representing Mounk Tounk. He's representing Quintavis Greer, looking at other cases of wrongful conviction centered in Fulton County, but some are, beyond the bounds of Fulton County. He is doing the work pro bono, but documents are extremely expensive. So I always try to pin this fundraiser in the descriptions. Thank you to Trakisha, and I know Factual Lie and the mods also share it. Putting it in the chat because I always forget. So super appreciate the mods. But it's a fundraiser to help cover the expenses of getting the transcripts, getting different filings, whatever he needs to send in and pay the fees for to get the documents he needs to research a case and see what was going on and if there might be some type of basis to file a habeas, or hey, there's an issue here, knock knock, what's going on. Also, big thank you to Chloe. Losing Ozzy and Malcolm Jamal Warner, then watching this, you can't help but to look at this guy and think, can we trade? Sorry, not sorry. I can't judge what how the human mind works. right? I think that's a valid question. And survivor's guilt for good people, well-intentioned people that haven't caused people to lose their freedom and livelihoods. I think survivor's guilt is a very real thing. I think more people should be familiar with it. And I don't think it's weird to wonder why some people go soon. How is it chosen? I think those are all things that we have to reflect on our own, and we all come up with our own reasons and philosophies. So love and appreciate you, Chloe, and glad that you're here with us. And thank you. We also, actually, wait, okay, perfect. On my end on StreamYard, if there isn't a space, the URL doesn't work, but I think it shows up for you guys over on YouTube. So there we go. I think I'd set this to jump over to Brian Koberger with, let me make sure he's still live, with Lawyer You Know. It might have ended. Let me see. He's usually not on all that long. Yeah, I think he's off. So who else is live right now? Let's see. I see a bunch of scheduled streams. Nothing really live, you guys. So we might just end with an ABCs of Steel and call it. So there we go, you guys. Thanks again for hanging out. And if you're new to the channel, thanks for helping us watch this rewind. If this is a first time for you, here's one of our favorite songs on the channel, all about Brian Steele.
A as in Alicia, and B, Your Honor, as in Barry. C as in Colette. G as in Goldfetter. K as in Kittens. M as in Magic. P as in Perfect. C as in Colette. U as in Unbelievable. V as in Victory. W as in Wonderful.
O for objection. S for sustain. E for buffering. E for Petrovane. S for sly, my friend, and you as in what you mean. I as in I don't recall. M as in may I sleep. All the ABCs of Steel makes me feel so real. Yeah, they keep on spinning round. Never gonna let me down. G for gavel slams down P. T for tell him anything. R for rights we stand. I for infinity. Life's a courtroom dance. Keep your stances strong. With ABCs of Steel, you can never go wrong. Oh, the ABCs of Steel makes me feel so real. Yeah, they keep on spinning round. Never gonna let me down. Steel makes me feel so real. Yeah, they keep on spinning round. Never gonna let me down. Oh, the ABCs of Steel.